Supreme Court and other high court citations proving that no license is necessary for normal use of an automobile on common ways, the right of a citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. Thompson v. Smith, 154 SC 579, 11 American Jurisprudence, Constitutional Law, Section 329, page 1135. The right of the citizen to travel upon the public highways and to transport his property thereon, in the ordinary course of life and business, is a common right which he has under the right to enjoy life and liberty, to acquire and possess property, and to pursue happiness and safety. It includes the right, in so doing, to use the ordinary and usual conveyances of the day, and under the existing modes of travel, includes the right to drive a horse-drawn carriage or wagon thereon or to operate an automobile thereon, for the usual and ordinary purpose of life and business. Thompson v. Smith, Supra. Tech Lines v. Danforth, Miss. 12 S.2d 784. The right of the citizen to drive on a public street with freedom from police interference is a fundamental constitutional right. White, 97 CAL.APP.3D.141, 158 Cal. RPTR. 562. 566-67 1979. Citizens have a right to drive upon the public streets of the District of Columbia or any other city absent a constitutionally sound reason for limiting their access. Conacia Mills v. D.C. 2009. The use of the automobile as a necessary adjunct to the earning of a livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. Barbarian v. Lucier, 1958, 139 A2D 869, 872. See also Schechter v. Killingsworth, 380 P.2D 136, 140. 93 Arizona 273 1963. The right to operate a motor vehicle, an automobile, upon the public streets and highways is not a mere privilege. It is a right of liberty, the enjoyment of which is protected by the guarantees of the federal and state constitutions. Adams v. City of Pocatello, 416 P.2D 46, 48. 91 Idaho 99 1966. A traveler has an equal right to employ an automobile as a means of transportation and to occupy the public highways with other vehicles in common use. Campbell v. Walker, 78 Atl. 601, 603, 2 Boyce, Dell. 41. The owner of an automobile has the same right as the owner of other vehicles to use the highway. A traveler on foot has the same right to the use of the public highways as an automobile or any other vehicle. Simeon v. Lindsay, 65 Atl. 778, 779. Hunnigan v. Wright, 63 Atl. 234, 236. The right of the citizen to drive on the public street with freedom from police interference, unless he is engaged in suspicious conduct associated in some manner with criminality, is a fundamental constitutional right which must be protected by the courts. People v. Horton 14 Cal. Ep. 3rd, 667 1971. The right to make use of an automobile as a vehicle of travel along the highways of the state is no longer an open question. The owners thereof have the same rights in the roads and streets as the drivers of horses or those riding a bicycle or traveling in some other vehicle. House v. Kramer, 112 NW3. 134 Iowa 374. Farnsworth v. Tampa Electric Company 57 So. 233, 237, 62 Florida 166. The automobile may be used with safety to others users of the highway, and in its proper use upon the highways there is an equal right with the users of other vehicles properly upon the highways. The law recognizes such right of use upon general principles. Brinkman v. Pachulike, 84 Nebraska 762, 764, 41 IND. Ep. 662, 666. The law does not denounce motor carriages, as such, on public ways. They have an equal right with other vehicles in common use to occupy the streets and roads. It is improper to say that the driver of the horse has rights in the roads superior to the driver of the automobile. Both have the right to use the easement. Indiana Springs Company v. Brown, 165 IND. 465, 468. U.S. Supreme Court says no license necessary to drive automobile on public highways/streets. No license is necessary. Copy and share freely. YHVH. Name 2 A highway is a public way open and free to anyone who has occasion to pass along it on foot or with any kind of vehicle. Schlesinger v. City of Atlanta, 129 Southeast 861, 867, 161 GA. 148, 159. Holland v. Shackelford, 137 Southeast 2nd, 298, 304, 220 GA. 104. Stavola v. Palmer, 73 A.2D 831, 838, 136 Connecticut 670. There can be no question of the right of automobile owners to occupy and use the public streets of cities, or highways in the rural districts. LeBrick v. Crandall, 126 NW 69, 110 Mine. 454, 456. The word automobile connotes a pleasure vehicle designed for the transportation of persons on highways. American Mutual Liability Insurance Company versus Chaput, 68.2D 118, 120, 95 New Hampshire 200 Motor Vehicle, 18 U.S.C. Part 1 Chapter 2 Section 31 Definitions, 6 Motor Vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways. 10. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge or other consideration, or directly or indirectly in connection with any business or other undertaking intended for profit. A motor vehicle or automobile for hire is a motor vehicle, other than an automobile stage, used for the transportation of persons for which remuneration is received. International Motor Transit Company vs. Seattle, 251 p. 120. The term motor vehicle is different and broader than the word automobile. City of Dayton vs. Debris, 23 NE.2D 647, 650, 62 Ohio Ep. 232. Thus self-driven vehicles are classified according to the use to which they are put rather than according to the means by which they are propelled. Ex parte Offert, 148 NW 20. The Supreme Court, in Arthur v. Morgan, 112 U.S. 495, 5s. Court 241, 28 L. ed. 825, held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Hillhouse v. United States, 152 F 163, 164, 2nd Circle 1907. A citizen has the right to travel upon the public highways and to transport his property thereon. State v. Johnson, 243 p. 1073. Cummins v. Holmes, 155 p. 171. Packard v. Banton, 44 S. Court 256. Hadfield v. London, 98 Wash 516. Willis v. Buck, 263 PL 982. Barney v. Board of Railroad Commissioners, 17 P.2 D82. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Chicago Motor Coach v. Chicago, 169 Nebraska 22. Lager v. Chicago, 28 Nebraska 934. Boone v. Clark, 214 SSW 607. 25 M. Year. First, Highways Sec. 163. The right of the citizen to travel upon the highway and to transport his property thereon in the ordinary course of life and business is the usual and ordinary right of the citizen, a right common to all. Ex parte Dickey v. Davis, 85 SE 781. Every citizen has an unalienable right to make use of the public highways of the state. Every citizen has full freedom to travel from place to place in the enjoyment of life and liberty. People v. Nuthouse, 147 Colo. 210. No state government entity has the power to allow or deny passage on the highways, byways, nor waterways, transporting his vehicles and personal property for either recreation or business, but by being subject only to local regulation, that is, safety, caution, traffic lights, speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. Chicago Coach Company v. City of Chicago, 337 Illinois 200, 169 Nebraska 22. Traffic infractions are not a crime. People v. Battle. Persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of right may ignore the law and engage with impunity in exercise of such right. Shuttlesworth v. Birmingham 394 U.S. 147 1969. U.S. Supreme Court says no license necessary to drive automobile on public highways/streets. No license is necessary. Copy and share freely. YHVH. Name 3. The word operator shall not include any person who solely transports his own property and who transports no persons or property for hire or compensation. Statutes at Large. California Chapter 412 P.83. Highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. Escobedo v. State 35 C2 D 870 and 8 Cal. Your 3rd P.27. Right. A legal right. A constitutional right means a right protected by the law, by the Constitution. But government does not create the idea of right or original rights. It acknowledges them. Bouvier's Law Dictionary, 1914, p. 2961. Those who have the right to do something cannot be licensed for what they already have right to do, as such license would be meaningless. City of Chicago v. Collins 51 Nebraska 907, 910. A license means leave to do a thing which the licensor could prevent. Blatz Brewing Company v. Collins, 160 P.2 D 37, 39, 69 Cal. A. 2nd, 639. The object of a license is to confer a right or power, which does not exist without it. Payne v. Massey 19__196 SW 2nd 493, 145 Text 273. The court makes it clear that a license relates to qualifications to engag,